2024, an election year like no other. From the candidates to the issues, from voter integrity and analysis, we'll discuss debates, trends, patterns, election laws, and more. This is Vote 2024, Path to the Polls.
If I say Chevron, what comes to mind? Perhaps it's the name of a gas station where you pull in and fill up your tank. Well, fact is, many Americans may not realize that a decision by the Supreme Court is very much in the news. The Chevron decision. Yet its importance and relevance should make it as common as a reference as is the gasoline moniker. Why? Well, that Supreme Court decision is potentially a risk to every household in America. They struck down what's known as the legal principle of Chevron deference. Here's the bottom line. It's one less tool for governing. The Chevron decision essentially gave federal agencies the authority to issue rules that are not clear. There are potential impacts on the environment and public health. Advocates worry the decision could set back efforts to reduce air and water pollution, restrict toxic chemicals, or even take on new public health threats like COVID-19, environmental and public health. Depending upon who you talk with in Congress, it means an increased role for lawmakers. Some say it restores an appropriate balance. Others say the court's conservative majority shamelessly gutted longstanding precedent in a move that will embolden judicial activism and undermine important regulations. And worry is it opens the door for large corporations to challenge a host of federal rules and, as environmental group advocates put it, grants every Trump-appointed judge the authority to overrule agency experts' interpretation of the law and substitute their ideological viewpoint for the informed determination of career public servants. Welcome to Path to the Polls. I'm Bruce Hamilton, and joining me is my friend, constitutional law expert Rod Sullivan. Appreciate you being here.
Glad to be here, Bruce.
All right, so let's start with the Chevron decision itself. What is it, and what did the Supreme Court rule?
Well, I think you're right. As a matter of fact, of the last term of the Supreme Court, the Chevron decision will probably have the most long-lasting impact. So what did the Chevron doctrine say? Well, 50 years ago, the Supreme Court said that when an agency is interpreting statutes that apply to it or what it enforces, the court's going to grant deference to the agency's interpretation of the law. And so consequently, the courts no longer become the primary interpreter of congressional intent, but the agency becomes the primary interpreter of congressional intent. Now, the Chevron doctrine didn't just come out of nowhere. I mean, this has been in the works for 5 or more years. The court had passed something called the Major Questions Doctrine maybe 5 years before it. It said, we're not going to presume that Congress delegated to an agency of unelected career bureaucrats the right to make major policy decisions that have economic impact or have political impact. We're not going to let the political decisions of this country be made by unelected officials. We're going to require Congress to do that. And that was sort of the precursor of what happened in Chevron. Now, my argument is that Chevron is the largest victim of the COVID crisis. Now, it didn't get COVID. The justices didn't get COVID. But during the COVID crisis, a lot of agencies exercised power that nobody thought they had. And the Supreme Court came in time after time and said, you, the agency, don't have the power to do that. Let's take the eviction moratorium as an example. The CDC had a statute that was passed in 1944. Remember, 44, that's what, 70 years ago? That said you have the right to quarantine infected animals and to disinfect their places of habitation. And so the CDC said, well, you know, people are animals, and therefore we must have the right to quarantine people. And if we have the right to quarantine people, we have the right to keep landlords from evicting them, even if they don't have COVID, and therefore we're going to enact a nationwide ban on evictions. No state in this 50-state nation shall evict anybody who doesn't pay their rent. And therefore, you know, thousands of people said, well, geez, you know, if I don't have to pay my rent and I can't get evicted, I'm just going to go ahead and overstay my lease. And that's what happened. And that went up to the Supreme Court twice. And finally, the Supreme Court said, no, this 1944 statute letting you quarantine animals does not give you the right to end evictions throughout the United States. So that was one example. Then we had the OSHA example of vaccine mandates. OSHA was passed over 50 years ago. And OSHA said, hey, we have the right to protect people in the workplace. And since people come into the workplace from the community, they may have COVID, they may pass it on. Therefore, 84 million Americans need to get the vaccine, whether they want to or not. And if they don't get the vaccine, they're out of work. They got to go. And that went up to the Supreme Court, and the Supreme Court said, no. First of all, the other thing you ought to understand is they didn't do this with notice and comment rulemaking. They didn't request the public to comment on this. They just simply said, this is an emergency. We're going to enact this. 84 million people, go out and get your vaccine. We don't care if you don't want it, if you think it's dangerous, if you don't want to do it. We don't care. You got to get vaccinated. Went up to the Supreme Court. The Supreme Court said, you don't have that power. Congress has that power. They can do it. Congress can enact an eviction moratorium, but you as an agency of unelected bureaucrats, no matter how expert you are, cannot point to any place in a statute that gives you the authority to do this, and therefore we're going to strike it down. And there are many examples of this.
So, you brought up something, and I really didn't think about it until you just gave this explanation. If we didn't have COVID, would we be in a different place?
I think we would. I think, quite frankly, that what happened over the last 5 or more years is that agencies just felt they were so powerful, thought they were so invincible because of the Chevron doctrine, that they said, we can do anything we want. You, the courts, have to defer to our interpretation of the law. We may not be lawyers. We may not be experts in the law. The Constitution may not have granted us authority to interpret the law, but the Chevron doctrine does. And we are interpreting this statute to mean that we can do this.
All right, so let me get to the majority ruling. Writing for the court, Chief Justice John Roberts said, Chevron gave too much power to experts who work for the government, which is what you're explaining here. Courts, he said, must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. So does it essentially take tools out of the toolbox for the federal regulators now?
No question about it. This I don't want to say eviscerated because that's too strong a word. This doesn't do anything to regulations that already exist. But what it enables people to do is people who were affected by a regulation could go to the court and they could say, this agency has overstepped its power. And the court would say, Chevron, deference, we got to defer to the agency's interpretation of the law. And then Congress, let's say you were adversely affected by an agency decision, and you went to your congressman. Your congressman could throw up his hands and say, I didn't vote for this. I didn't want this. But you know, the agency has the power, and they decided this. I have to keep my hands off. So it really gave all of the discretion to these unelected public officials, call them bureaucrats if you want, career public officials, to make policy. And they were not just making small policies anymore. You know, during the first 40 years of the Chevron deference, the policy decisions that the agencies made were smaller. They weren't involving major political questions, resolving things that were disputes in the public sphere. They were deciding more minor decisions. And then as the agencies got more and more bold, they sort of shot themselves in the foot, because eventually people said, look, this is not within your power. Congress never granted you this power. Congress has the power, you don't.
So at the start of the program, I questioned whether or not this opens the door for large corporations to challenge a host of federal rules and, as environmental group advocates put it, grant every Trump-appointed judge the authority to overrule agency experts' interpretation of the law and substitute their ideological viewpoints for the informed determination of career public servants. Is that where we're at?
Well, yes and no. I would disagree with the characterization of this as giving power to major public corporations, because the ones who brought these suits to set aside the Chevron doctrine, these were little guys. Loper Bright versus the National Marine Fisheries Commission, they were just a small family fishermen. They had 2 or 3 little boats. And the statute that allowed National Marine Fisheries to monitor herring catches had been around for 50 years. And the government had put inspectors on boats and checked the herring catches. Well, all of a sudden, Congress didn't appropriate the money. So the National Marine Fisheries said, well, now, since we don't have the money, you have to hire our employees to go aboard your boats. You have to provide them room and board aboard your boats, and it's going to become, you're going to pay their salaries. okay? They're going to be working for us, but you're going to pay their salaries. And Loper Bright said, first of all, this is going to take away 30% of our profits. And these are little guys. And so they went to the courts, and the courts took it all the way up to the Supreme Court, and the Supreme Court said, no, you have the authority to monitor their herring catches, but you don't have the authority to make them pay for your monitors. So they were little guys. Take the Sacketts. There are folks that lived up in Idaho. They bought a plot of land on a non-navigable water on something called Priest Lake, and they started backfilling in their property to build their dream vacation home. And the water from their property ran into a ditch, and the ditch ran into a creek, and the creek ran into a river, and the river ran into Priest Lake, which was a non-navigable water, didn't connect to any navigable waters of the United States. And the EPA came in and said, well, it has a nexus because all of that water eventually is going to make its way to the ocean someplace or other. So we're going to tell you, you can't fill in your ditch because that water will eventually go to the navigable waters of the United States. And we're going to fine you $40,000 a day, every day, until you take all the fill out of that ditch. And eventually the fines worked to exceeded the value of the property. They're little guys. They're like you and me. They bought a plot of land. They want their dream house on an Idaho lake, and the EPA said you can't do it. Went up to the Supreme Court, and the Supreme Court said no. This is not a navigable, their ditch is not a navigable water. We don't care the fact that the water eventually flows into another body, that it flows into another body. It doesn't make it a navigable water. It's an isolated intrastate water. EPA, you don't have jurisdiction. So big corporations are going to be able to challenge regs, but the people who have come forward to the courts and said, we don't like this, have been little guys like us.
All right, so let's get down to brass tacks here. What are the potential impacts on environmental and public health?
Sure. Well, first of all, let's look at the big environmental question that has the environmental community messed up, and that is the Clean Power Program. Now, in 1970, that's 52 years ago now, Congress passed the Clean Air Act and said you can regulate existing power plants to prevent them from putting out sulfur dioxide and other pollutants. So 50 years goes by, and then the Obama administration comes and says, okay, well, we now determine that carbon dioxide, the stuff that you and I are breathing out right now, that's a pollutant, and we can regulate your CO2 output from your plant and effectively make you shut that plant down. And we can force you to create new electrical generation facilities that rely upon wind and solar. Now, you may think that's the greatest thing in the world. You may think climate change is the #1 issue affecting us and that the EPA should be able to regulate existing power plants and make them turn over to solar and wind. And whether you agree with that policy or not, the people who were making these decisions were not policy experts. They were not congressional experts. They were just ordinary career bureaucrats. And so what the Supreme Court said was, under this particular legislation, this 50-year-old legislation on which you're relying, you don't have the authority to make existing power plants that were built under the regulations that you established shut down and start making solar, using solar and wind. So whether you think that's a good policy decision or not, the question you need to ask yourself is, should I have the right to go to my congressman and complain that I don't like these regulations? Or do I have to simply abide by what the career bureaucrats say should be law, that should be done? So that's the major decision that environmental groups are affected by. I mean, they hate this idea of navigable waters. As far as they're concerned, your toilet is navigable waters. Why? Because when you flush that toilet, it goes into a pipe, which goes into a sewage system, which eventually is going to make its way into the ocean, and therefore the EPA should be able to regulate what's in your toilet. The other position of the environmental advocates is the same with regard to power plants. They should be able to, under existing law, shut down existing power plants, perfectly legal under the statutes passed when Congress passed the Clean Air Act, and make them invest in solar and wind and then pass the costs onto you, the consumer of electricity, in the form of higher costs. And the Supreme Court said, hey, you may have a very laudable motive, maybe a good goal, but guess what? This is a major question. Congress needs to do this, not you.
So should we worry about the red flags?
No, I really think what you should do is worry about your congressman getting off his tail and starting to pass legislation of this type. If you think that wind and solar is the future and you're willing to pay for it, go to your congressman and tell him, allow the EPA to shut down fossil fuel plants and replace them with solar and wind. And, you know, maybe provide the money for them to do that. Well, talk about how it affects you on a day-to-day basis, too. If you have kids that are in public schools, 50 years ago, Congress passed rules that prevent sexual discrimination in schools that receive public money. They need to treat men and women's sports the same. And 50 years ago, Congress knew what sex was. But then the Biden administration comes along 50 years later and says, well, we don't think sex really means sex. What it means is it's sex plus gender orientation plus sexual orientation. And therefore, if you are a public school and you accept federal money, you can no longer discriminate against people based upon their gender preference. So in other words, if you have a student whose gender preference is male, even though they have female sex organs, they can go into the men's room and vice versa. If you put Tampax in women's restrooms, you need to put Tampax in boys' restrooms and the like. And so, again, the Supreme Court looked at this and said, Congress 50 years ago never had any idea that their statute prohibiting sex discrimination was also going to prevent gender discrimination and sexual orientation discrimination. Therefore, we think this is a major political question that you are resolving that really ought to be resolved in the public forum. People ought to be able to tell their congressmen how they vote, how they should vote. Congressmen should debate this on the floor of Congress, and if they want this, they should pass the statute. They should amend the statute that's going to extend prohibition of sexual discrimination to prohibition for gender discrimination and orientation discrimination.
All right, Caleb, do me a favor. If somebody in the back could get Rod some water here.
Sorry about that.
No apology necessary. You know, this is a complex topic and requires a lot of explanation, so I want to make sure you're comfortable. Let me see if I understand what you're saying here. Chevron deference put a two-ton judicial thumb on the scale of government bureaucrats against the little guy. So if regulators want to win in the future, what is it they have to do to do a more careful job, as some have said, and resist the urge to push their own agendas?
Well, I think what they need to do is they need to lobby Congress. And of course, it's illegal, quote unquote, for them to lobby Congress. But Congress relies upon agencies in drafting a lot of this legislation. And so if the agency officials go to the Congress and say, well, this new issue of gender discrimination and sexual orientation wasn't around 50 years ago, but we think that as a matter of civil rights, you need to amend the statute to go ahead and include these in the Educational Act, Title IX statutes, and then try to convince Congress that that's the right thing to do. Now, Congress likes to dodge these hot political issues. They don't want to handle them, but that's really the way it should go. Is Congress should look at these issues, debate them, receive public opinion, and then go forward.
All right, let me get into the head of some of the people in Congress who are addressing this issue head on. And needless to say, there are differing opinions. Iowa Republican Senator Chuck Grassley said the ruling restores appropriate balance to the three branches of government. So does that put more pressure, extreme pressure on Congress to be more specific when they write legislation?
It does. It does. You know, the way the courts look at it now is if Congress passes a statute and leaves a gap, and the agency comes in immediately and fills that gap with its own interpretation, that's entitled to some deference, because it's assumed by being silent, Congress intended for the agency to fill the gaps in the statute. But if you have a statute that's 50 years old, none of those legislators are around anymore. None of them anticipated 50 years later that you are going to redefine the word sex to include sexual orientation or gender preference. And therefore, we're not going to grant deference to that. So, yes, I think this should ideally embolden Congress to actually take more action.
All right, then there's the other side of the coin. Senate Judiciary Committee Chairman Dick Durbin, an Illinois Democrat, sees it differently. He says the court's conservative majority, quote, just shamelessly gutted long-standing precedent in a move that will, quote, embolden judicial activism and undermine important regulations. There's the other side of the coin.
Sure. When you say embolden judicial activism, what it will tell courts to do is to rein in the agencies when they are exceeding their delegated authority. I'm not sure I consider that. Judicial activism is when the court substitutes its judgment for the judgment of Congress. This sort of reining in the power of regulatory agencies, I don't look so much as judicial activism. And of course, it works both ways. Under the Chevron doctrine, it was a court that decided that carbon dioxide was a pollutant to be regulated by the EPA. 50 years ago, when the Clean Air Act was passed, we assumed that they were going to regulate sulfur, sulfur dioxide, mercury, and other things which we now call criteria pollutants, but not the very stuff that we breathe or breathe out. But the court said, under the Chevron doctrine, hey, we're going to allow the EPA to regulate CO2. And that was, you could call that judicial activism. They extended the Clean Air Act to cover something that was never considered to be a pollutant back when the act was passed.
All right, so back to the Supreme Court decision and its impact. Safe to say the full impact will unfold over time and impact how bills are drafted on Capitol Hill?
Yeah, I think, ideally, I think that what Congress should do is that Congress ought to sort of take on its responsibility that's been delegated to it. You know, Congress doesn't really do much these days. I mean, yeah.
They certainly don't do enough.
They don't do enough. And when you look at all the hearings that they have on things that are really not going to result in legislation, really Congress should be spending its time passing laws, debating laws, receiving comments from the public, and then answering to the public. Right now, if you don't like what the government is doing, most of the time your congressman can't do anything about it. You can write a letter to your congressman. Your congressman will say, oh, I'm very concerned about this issue. As a matter of fact, I drafted a bill and filed a bill to correct the very problem you think of. And that goes into the Congressional bill hopper, which is all the thousands and thousands of bills that are filed every year by congressmen that will never even get brought up by the committee.
It's too busy lost in all the pork.
Well, that's right. I mean, when you're a congressman, you go into Congress and you start raising money the very first day so that you can run for re-election, because you got to do it again in 2 years or 6 years when you're in the Senate. And the way you do that is you get pork for these people who are your major contributors, and they give you money so that you can get re-elected. But the actual, the budget doesn't get written by every single congressman. It gets written by the Budget Committee, and the night before you're going to vote on it, you get this stack of documents and you say, yes or no, I vote for that or I don't vote for that. But as far as congressmen just passing statutes, they don't do that much. So consequently, I think that this is going to reinvigorate Congress. I hope it's going to reinvigorate Congress, and that they're going to start taking their responsibilities more seriously.
All right, now came to your rescue.
Thank you very much.
When Path to the Polls continues, what's next? Will judges be able to overrule agency experts' interpretations of the law and substitute their own ideological viewpoints? We kind of touched on that. Discussion continues after this quick break when Path to the Polls continues. You're watching Path to the Polls. Bruce Hamilton, along with constitutional law expert Rod Sullivan, talking about the Supreme Court's decision to reject a 40-year-old legal doctrine that effectively reduced the power of executive branch agencies like the EPA and shifted it to the courts. And the bottom line is that federal rules that impact virtually every aspect of everyday life, from the food we eat and the cars we drive to the air we breathe, could be at risk after the wide-ranging court ruling. So, Rod, Craig Segal, Vice President of the environmental group Evergreen Action, said the ruling opened the door for large corporations to challenge a host of federal rules. He said the dismantling of the Chevron doctrine grants every Trump-appointed judge the authority to overrule agency experts' interpretation of the law and substitute their ideological viewpoint for the informed determination of career public servants. Is that where things stand, or a bit of an overstatement?
No, it's an overstatement. The Supreme Court specifically addressed this in their opinion in Loper-Bright. They said, we understand that agencies have particular technical expertise in certain areas, but when it comes to interpreting the law, we are the experts, the Supreme Court. Agency officials are not necessarily lawyers. They don't know anything in particular about congressional intent in excess of what any other citizen might know. And therefore, when it comes to interpreting the law, we're going to take that discretion away from the agencies and want to bring it back to the courts, because we are the experts at interpreting congressional intent and interpreting the law. So if you have a technical issue, such as, for instance, what bandwidths radios ought to play on, or technical requirements for certain machinery or cars or things like that, there's no question about the court that's going to say, you, the National Highway Traffic Administration, have expertise in self-driving cars. You have expertise in roadway construction. You have expertise in signage, and we're going to defer to your expertise in those areas. But when you come to us and you're going to say to us, Congress delegated us this authority to do a major question, to make a major political decision, like everybody's going to drive an autonomous vehicle, everybody's going to drive an electric vehicle. Those are the decisions that really shouldn't be made by Congress. And we're going to determine whether the statute that you're operating under actually grants you that authority. Now, if, for instance, just a year or two ago, Congress said, we're going to mandate that electric cars become the majority of the vehicles by 2030, that's probably going to be an area where the Supreme Court's going to say, Congress decided this issue relatively recently. They delegated the responsibility to either the EPA or NHTSA, and therefore we're going to defer to them. But when you have a 50-year-old statute, and then you suddenly find a new interpretation, the Congress is going to say, no, Congress 50 years ago didn't grant you this discretion, this authority, and therefore we're not going to grant it any deference. We're going to analyze the statute, the congressional intent, and we're going to tell you whether you have discretion to do this or not.
I want to talk specifically about the automakers in just a bit, but I want to get back to Congress and the lawmakers' standpoints, because, as we pointed out before, there are differing reactions. Senate Minority Leader Mitch McConnell said the days of federal agencies filling in the legislative blanks are rightly over. And then you have Massachusetts Senator Ed Markey, who said the ruling creates a regulatory black hole that destroys fundamental protections for every American. Is there some sort of a middle ground here, some sort of appropriate balance that can be found?
Well, you'll notice that all the people that are in favor of the Chevron doctrine now are on the Democrat side of the aisle, and all those opposing it are on the Republican side of the aisle.
It's political.
It's very political, and I think the feeling of Republicans is that the people who work in the agencies are primarily on board with the Democrat agenda. And if you look demographically at the District of Columbia, Northern Virginia, and Maryland, it bears it out. Those areas are overwhelmingly Democrats. Most of the quote-unquote bureaucrats, the career public officials in Washington, D.C., tend to lean left, tend to agree with the Democrat side of the Congress and not with the Republican side. So therefore, the Democrats would like these agency officials who agree with them to have ultimate discretion. And the Republicans, like Mitch McConnell, want to have no discretion on behalf of the agencies. So I think the middle ground is the middle ground that probably the Supreme Court has decided. And that is, we're going to decide when they get deference and when they don't. When it comes to an interpretation of their power, we're not going to give them deference. When it comes to interpretation of the specifics of a statute, technical things on which they have expertise, we are going to defer to them.
All right, let me get to the issue of auto safety. I know that the automakers are already petitioning the NHTSA, and they're saying, well, look, with this ruling, let's take another look at things, petitioning things we have to reconsider. The performance standards that they've asked us to meet are nearly impossible with current technology. A sign of things to come?
Yeah, well, I don't know. If Congress, I cite this example because Congress has very recently legislated on this and has indicated a preference for electric vehicles, re-electrification, more power plants and everything else. So there is sort of a policy statement there from Congress. And if the EPA and NHTSA are filling in the blanks from this relatively recent legislation, it's likely, I think, that the Supreme Court and the courts will grant them deference in determining how to do this. It may be wrong. I mean, maybe electric vehicles are not the answer. Maybe the electric vehicles do not reduce carbon dioxide output. But if Congress made a mistake and NHTSA and EPA are interpreting the statutes under this statute that Congress made the mistake on, I think the courts are going to say, hey, you made it, you fix it. It's only when the agency really extends beyond what Congress could ever have anticipated happening that they're setting them aside.
All right, let's put a bow on this. In your opinion, has there been federal overreach to this point?
There's no question about the fact that, in my opinion, during the COVID crisis, there was overreach. In the EPA and the navigable water rules, there has been excessive oversight. I'm not so sure about with regard to the Clean Power Act because, quite frankly, I don't fully understand it, so I hate to opine on that. But Congress, the Supreme Court has struck it down twice, so I assume that they know what they're doing. So I think, yes, the agencies brought this about themselves. They overextended their own power. They asserted they had powers that they didn't have, and therefore they caused the demise of the Chevron doctrine.
I know some Democrats are pledging to push for a restoration of the Chevron doctrine, but there's a big divide in Congress, long reach.
Well, yeah, it doesn't, it doesn't take but a few more congressmen and a few more senators to go ahead and make the Chevron doctrine law again. And so who knows what's going to happen in November. If the Democrats hold on to the Senate and take Congress and there's a Democrat president, yeah, I could see Chevron getting reenacted as a statute instead of as a judicial rule.
All right, time will tell.
Vice versa. If there's a Republican president or there's a Republican House and Senate, I don't see any change happening.
The elections will tell. And there's some other Supreme Court issues that you and I have been talking about, so you'll come back maybe late September, early October, and we'll discuss those.
Absolutely.
Always fascinating. You provide wonderful context, perspective, and focus, so I appreciate you being here on Pass the Polls.
Thanks, Bruce. Always a pleasure.
And we appreciate you. There's an encore performance tonight at 7 o'clock, and you can always watch on-demand streaming on news4jax.com and the News4Jax YouTube channel. And if you've got any questions, you can always email me here at the station. I appreciate hearing from you, and I appreciate your time.
See why every day more people are choosing News4Jax, Northeast Florida and South Georgia's #1 source for local news.